permitted to mention one matter? Your Lordship, there was a preemptive order passed to remove the defects, Your Lordship. There is one defect that the copy of decree of first appellate court may be sent for correction. So we have filed an IA for a direction that the copy of decree may be sent for correction, Your Lordship.
So you have not informed the master.
Your
The
Lordship,
period has expired?
No, period has not expired, Your Lordship.
For passing appropriate order to that effect.
Yes, Your Lordship. We have
Period
filed
अभी expired नहीं हुआ तभी list होगा
नहीं हुआ, Your Lordship. Tomorrow is the last date.
Notify कर दीजिए. Notify कर दीजिए. हाँ, कल last day है तो.
कल है.
आपको उसमें भी objection है?
No, Your
हाँ
Lordship.
तो बस.
This case from daily list, item 22, second appeal 493 of 2018.
The cancellation deed of the adoption deed.
Yes.
Was it executed?
Your Lordship.
She took a plea that there was a cancellation deed of
Yes,
adoption.
yes.
Was it exhibited?
Was it?
Exhibited.
Yes, it was.
Exhibit number?
And Your Lordship, over and above that, they themselves in their plaint itself they have mentioned that we had executed a cancellation deed and thereafter.
No, we appreciate that. That is by limitation.
Yes, sir.
You see, they cannot say that they are naive. She was conscious of the fact
Yes,
that there
yes,
is an
therefore, yeah.
adoption. Therefore, I just wanted to know, was it exhibited?
Yes, Allah.
You are for the defendant, I suppose.
I am the defendant.
And you are for the plaintiff.
Yes, Your Lordship.
What is the exhibit number of the cancellation deed?
All the exhibits those have been mentioned in page 5 of the trial court.
इसका रिकॉर्ड वो दीजिए इसका वो जो ब्रीफ है वो दीजिए सेकेंड कॉपी के साथ इसका सर्टिफाइड कॉपी लगा हुआ कहीं भी लाके ना वापस रख देते हैं ये देखिए यहाँ लगा हुआ ट्रायल कोर्ट जजमेंट पेज नंबर
Page 5, internal page 5.
yes
That has not been exhibited. Only
That-
these
that
documents.
has not been
That has not been exhibited, Your Lordship.
Only
Only two
these-
documents have been exhibited by the plaintiff,
Yes.
the respondent.
but the plaintiff herself claimed that there was a cancellation
Yes, Your Lordship. That is a fact.
so she was conscious of the fact
She was conscious of the fact that there was existence of a adoption deed in the year 1975.
Yes.
She took an endeavor by filing up of cancellation deed, though
they
it
do
was
not proved. Not proved. If there
Yes,
is a
Your
deed of cancellation, that ought to have been exhibited.
Yes, Your Lordship, that must have been. That has not been done. That is a matter of fact, and I
Yes.
cannot controvert it.
So, and ultimately, she did not take any step further. She claims to have executed a cancellation deed, but she did not take any step to challenge the deed.
No, Your Lordship, he didn't.
It is barred by limitation, ex special.
Lordship,
Now, please explain. And according to him, you were there on the last day?
Yes, Your Lordship, I was there.
He says that if first question of law is answered,
The remaining, the limit, if the question.
remaining becomes, but since a question of law has been framed,
Yes, Your Lordship.
we will just hear you on the point of limitation, and then we have to answer the other questions also. We cannot just leave it like that,
Absolutely.
Yes, Your Lordship.
right? So you just tell us.
On
How
the,
do you
only
meet
on a
with-
point of law.
Only on.
First, I
You want to still
yes,
argue?
yes, yes.
Continue.
Your Lordship may, because I don't have the plaint, but the entire plaint has been mentioned by the trial court. Your Lordship, exact verbatim it has been mentioned. Your Lordship may see the internal page 2 of the trial court judgment,
Yes.
where this particular fact, I am not reading the entire fact. last approximately 10 lines from the bottom. The plaintiff number 1, Shanti Kumarin, and the defendants had come
Just-
to
just
Dumka Registry
one-
Office.
Just a moment.
Or if your lordship says, I can read the entire.
No, not. Yes, plaintiff number 1.
Yes, Shanti Kumarin and the defendants had come to Dumka Registry Office on 25/6/1975 for execution of a Bhogat Pandha deed with a view to grab the land of said Shanti Kumarin. The defendant number 2 fraudulently manufactured a deed of adoption in favor of his son Pawan Raut. After some time, the defendant number 2, Saudagar Raut, told the plaintiff Shanti Kumarin about the adoption deed, and on the inquiry, the plaintiff learned about the matter on 18/8/1975. This is very important.
Yes.
So this is the date of knowledge about the deed which she says was a fraudulent. It was a mortgage deed, and she actually it was an adoption deed
Bhugut
which was
Bandh
shown.
deed is mortgage deed. Bhugut Bandh deed is a
Bhogat
mortgage deed.
Pandha is a mortgage. So in the garb of execution of mortgage deed, an adoption deed was executed by her. So she says that she came to know about it on 18/8/1975. Then the plaintiff executed a deed of cancellation, adoption deed 478 of 1975, dated 23/6/1975, before the registry office Dumka. The cause of action for the suit now arose on so and so with the defendants also. So my entire argument would be
This cancellation of adoption deed, no further detail has been given.
no. Now, my argument would be that on 18/8/1975 itself, the cause to get the deed cancelled arose. And your lordship may kindly see few provisions of Limitation Act, your lordship.
It is governed by which article?
Judgment also, but
Which
before
act?
placing that, I'll
Which
just
article?
place the Limitation Act.
Which article?
Limitation Act.
Which article of the limitation?
Yes, before Article 59.
59. Yes. Yes. It's very, very
Says-
clear, there is no problem about it.
No, I'll just point out one thing.
Yes.
On the right side, this Article 59 would apply. It says to cancel or set aside an instrument or a decree for the rescission of contract, 3 years. And the right side is very important. When the facts entitling the plaintiff to have the instrument or decree cancelled or set aside, the contract resided first becomes known to her. Therefore, if this is applied in our case, then it first became
No, you
known
have-
to her.
You have already argued
Yes,
this,
yes.
don't repeat it.
No, I'm not.
You see, we are conscious of this fact. Now the only thing which he can say is that there was no need for getting it cancelled.
Yes.
That is the only thing he can
Yes,
argue.
Yes.
Now let us see whether he can make out a case that
Yes.
there was no need for cancellation.
That is. Otherwise,
So otherwise if there was a need for cancellations, Article 59 would apply.
absolutely.
Now I'm sure that he is
Now-
argued
now-
on that
So
line.
I'll be
I'll answer to it. Today now he has given me a bunch of these.
अब आप इतना सीनियर हो
नहीं,
गए
नहीं।
टुडे टुमारो मत करिए।
नहीं ये अभी bunch हमको पूरा जजमेंट
कोई बात नहीं, आप भी पढ़िए,
हम
हम भी
देख-
पढ़ते।
Your Worship, I'll
Just a moment. On one point, one judgment is sufficient, right? Multiplicity of judgment will not improve your case. You choose the best judgment if they are on the same point. Unnecessary जो है ना, हमको
Unnecessary,
judgment लंबा नहीं बनाना
नहीं
है।
लंबा
एक बेस्ट जजमेंट चूज कर लीजिए on the point that you need not.
स्लाइटली सब डिफर कर रहा है इस
जो आप चूज कर लीजिए आपको कौन सा प्रिंसिपल ऑफ लॉ तो यही है ना, whether you need to challenge that deed or you don't need to challenge that deed.
Yes. One of the issues is that since there was non-compliance of section 11(6), then in the light of section 5, 6, read with 11 subclause 6 and 12, there was no necessity of challenging the same.
Okay.
One of
You are
this is an
referring to-
alternative
Just a
argument.
moment. You argue it. Do you say, first point, do you say that Article 59 is applicable?
Your Lordship, assuming but not conceding.
Assuming नहीं, आप बताइए applicable है कि नहीं है. If you say no, I would like to know from you.
There are
why.
alternative arguments.
We will hear that.
The first issue is that it is applicable,
Okay.
and there are other factors, if considered, why the appellate court, while dealing with this particular issue, has opined that the trial court judgment was bad in law.
Okay.
And the leadership must kindly refer to page 28 of the just one paragraph from the appellate order.
Okay.
How the same has been dealt. Just one paragraph I'll read.
Which paragraph?
The second paragraph at page 28.
Uh,
वाद पत्र की कंडिका 20.
This does not have a para number. Page number, give
Page
me
number
internal
28.
page because your numbers do not tell. Internal page? It is there at the Prisht Sankhya 2. You just tell us which page number is that.
21, sorry.
21 of the appellate court judgment.
Appellate court.
Internal page.
Yes.
Correct? Yes.
वाद पत्र की कंडिका 20 के अवलोकन से दर्शित होता है कि दिनांक 12/9/2007 को वाद पत्र दाखिला के लिए वाद कारण उत्पन्न हुआ जब पुलिस के समक्ष प्रतिवादी दत्तक विलेख संख्या 478-75 के जरिए दावा करने लगे। इस बात में दम है कि हर कार्य के लिए कोई कारण जरूर होता है और जब धारा 144 दंड प्रक्रिया संहिता के मुकदमे में जो शांति कुमराइन द्वारा अनिल लाल कुमार के खिलाफ चलाया गया उसमें पुलिस के समक्ष प्रतिवादी पक्ष द्वारा दत्तक विलेख के आधार पर दावा किया गया। वादिनी ग्रामीण विधवा जाहिल गंवार महिला रही है जो मात्र निशानी अंगूठा देना जानती है। पति के गुजर जाने के बाद उसके सिर का मौर समाप्त हो चुका है। विधवा होने की स्थिति में सारी अकल उसकी गुम हो चुकी है। उस परिस्थिति में जालसाजी करके भुगत बंधा के द्वारा प्रतिवादी गण द्वारा जाल फरेब कर दत्तक विलेख का निष्पादन कराया गया है। एक जाहिल गंवार महिला जो वैधव जीवन व्यतीत कर रही है जिसके आगे पीछे कोई नहीं है उसको तो हर व्यक्ति का सुझाव उसके हित में कल्याणकारी लगेगा और उसके सुझाव के अनुसार वह कार्य करेगी। जब उसके पिता से प्राप्त संपत्ति जमाबंदी नंबर सो एंड सो विवाद में आई तो उसके द्वारा विधि सम्मत कारगुजारी की गई है और दिनांक 30/1/2008 को नजदीक अदालत वादपत्र अर्पित किया गया है। इस तरह वादिनी के वास्तविक जानकारी दिनांक 12/9/2007 को हुई है। उस दिन वाद कारण उत्पन्न हुआ है और नियमतः नजदीक अदालत वाद पत्र अर्पित किया गया है जो जानकारी के 3 साल के अंदर ही वाद पत्र अर्पित है। This was the finding which has been
Just a
given.
moment. This is the finding recorded by the learned court by recording that she is illiterate, she does not know anything. And
Backed up by the Supreme Court judgments.
No, you will see that. And the cause of action is taken as 12/9/2000.
7. Yes, Your Lordship.
This is the finding of the appellate.
Yes, Your Lordship.
I want to know from you, does the finding of the appellate court takes into consideration the specific case of the plaintiff? That she came to know about it on such and such date and thereafter she also went to get the deed cancelled. Does that reflect that
No.
she is not aware about law? Her own case that she went for a cancellation deed, though not exhibited, does it reflect that she is not aware about what is to be done?
No, it does not reflect that.
Then does it not amount to applying certain parameters which is not born out of the plaint? It is not born out of the plaint.
The social parameters have been considered.
Social
but
parameters has to be backed by evidence or the materials on record. What is the material on record to say that she is absolutely
The
unaware?
facts which have been considered by the appellate court is that there was a deed executed in the year 1975, which, to the best knowledge of the illiterate lady, she might have done something for cancellation, though not exhibited, but she might have done. Let's just keep it aside. Secondly, in the year 2002, believing that the earlier deed is not in existence, she adopted another son. Had she known that the 1975 deed is still in existence, 2002 would be bad in law, the adoption. Then the again cause of action when she came to the knowledge of the fact that
which is that exhibit, the second adoption deed? What is the exhibit number of the second adoption deed?
Exhibit 2 at page 5 of the trial court judgment. The original registered adoption deed 1017 dated.
In favor of Kundan Kumar.
He
Kundan Kumar is defendant?
Number 2. Oh, sorry, plaintiff number 2. Here defendant.
So she wants to enforce the second adoption deed.
She is continuing with the second adoption. She is not. There is no question about the second adoption. 2002 में there was a second adoption done. Had she known that the earlier one is still in existence, this would have been barred by law.
Continuing means what? What is the meaning of continuing?
Continuing. Sorry.
Continuing with the second adoption deed means what?
No, not continuing. She is accepting that another son in the year 2002 was adopted.
You are seeking a declaration. You just see what is the declaration. What is the relief that the plaintiff is seeking?
Cancellation of adoption deed number A478 dated
Yes.
1975, declaring that the defendant number 1 is not the adopted son.
Yes. So you are seeking a cancellation.
I was seeking only cancellation.
Yes. So
If I was seeking that the latter deed of 2002, it needs to be enforced. That would have meant that I had this thing in my mind that this needs to be enforced.
you are not seeking.
This is the bona
enforcement
fide of the plaintiff. This was the bona fide of the plaintiff that she never knew about it. Lordship, I'll just rely on 2 paragraphs.
There is a finding in that she never knew till 2002. She had no idea that the earlier deed was not cancelled. Is it based on your pleadings that
No.
you have no idea that it was not cancelled?
It is based on the conduct.
No.
Had
we
she
are
idea,
we are not here to adjudicate on the conduct
if
at the
she
first
had,
instance.
Lordship, just consider one fact. If she had the knowledge that there was an existing son who was adopted in the year 1975, would 2002 deed of adoption be valid?
You see, I'll tell you one thing. We are in a second appellate stage.
Yes, Lordship.
Whatever you speak, that has to be backed by some material on record. Please do not give a lecture. We are not interested in
No,
anything.
I'm not giving a lecture.
Whatever you are speaking, you speak from the record.
Two-
And show is the moment you speak a sentence, I'll ask you show it from the record.
2002 deed is exhibited, that is on record.
Yes.
1975 deed, if it is upheld, now as per law, the 2002 deed becomes, the adoption becomes null and void.
Certainly.
That is the thing which I was just trying to exhibit, that this is going to be a problem for that. Now, let's go to the compendium of judgments on the point of limitation and illiteracy part, which
Which judgment?
Lordship, I'll just refer to directly to only 2 small paragraphs. Lordship, page number 5,
Of
the entire compendium.
page number 5 is a part of which judgment? Number 2.
No, the judgment starts from page number 5. Ravi Namdev Kavale and others versus Kittaswamy and others.
Karnataka.
Yes, Your Lordship. Citing a Supreme Court judgment.
So you cite the first Supreme Court judgment, no? If there is a Supreme Court judgment on the same point, you cite the Supreme
So
Court
just,
judgment first.
to maintain the coherence in which I have prepared myself, I'll try to just demonstrate in this manner. Your Lordship, I kindly refer to page 6, the last line.
Just a moment. In the index table of content, it is which judgment?
Second.
Number 2.
हाँ. इंडेक्स थोड़ा ऊपर नीचे होगा, ऑटो जनरेटेड था लीडरशिप
कोई
इसकी.
आपने कॉलम में नहीं डाला इसलिए.
Auto generated, I am not so well versed with the technological things, so that's why.
Yes. What do you want?
The last line, page
Of
6.
Page 6. Yes.
in the case of MP Sugar Mills versus State of UP, cited at so and so at 69, it has been observed that, moreover, it must be remembered that there is no presumption that every person knows the law. It is often said that everyone is presumed to know the law, but that is not a correct statement. There is no such maxim known to the law. Over 130 years ago, so and so pointed out. Leadership, just skip few lines. The quoted lines are ending. It is one of the principles of
नहीं skip हम कुछ नहीं करते हैं पढ़ते समय. You read it.
pointed out that in Martindale versus Frankfurt, there is no presumption in this country.
This is 1846 judgment.
Yes, Your Lordship.
Right?
There is no presumption in this country that every person should know the law. It would be contrary to the common sense and reason if it were so. So and so also once said that it is impossible to know all the statutory law and not very impossible to know all the common law. From here it is very important. It is one of the principles of our constitution that no person should be deprived of the legal remedies because of economic or other disabilities. Illiteracy is also a disability and a consequential ignorance of law of limitation. As such, it can be said to be a disability of a person as economic disability. In the view of the matter relating to the right of a person to approach a court to obtain a legal relief unless mala fide is shown or established simply on the ground of ignorance of law or lack of knowledge of law of limitation, or like no other person should be punished for delay of filing the appeal by dismissing the appeal as time barred.
You see, there is a different concept when a person is dealing with appeal and when the person is dealing with suit.
Yes, Your Lordship.
When suit comes, show me from the Limitation Act that this could be a ground to ignore the point of limitation.
The limitation is not only a statutory prohibition. There is a statutory bar indeed, but it also embeds the concept of waiving of right.
Who has waived the right?
She has not waived the right. Had she waived the right, she would not have appeared before the court. She never waived the right because as soon as she came to the conscious knowledge that there is a deed of adoption in existence which is being acknowledged by the government authorities, the moment she came to know about the same in the year 2007, she came straight away to the court challenging it.
Okay.
Leadership, now coming to the
What else you want to say?
alternative arguments that there was no need to challenge it.
Firstly, you say it is not barred by law, though it is barred by limitation. Right?
It is not
This
barred
is
by
what-
law. There is
Though
still-
it is barred by limitation.
Ha.
So
Assuming
first-
but not conceding.
No, just a moment. No. Okay. Yes.
Secondly, that
No need to challenge.
there was no need to challenge the adoption deed which was executed, rightly or wrongly, in the year 1975. Lordship, I'll just go through the statute for once. Lordship, kindly refer to section 5
Of
Hindu Adoption and Maintenance
like
Act.
Hindu Adoption and Maintenance Act. Yes.
Section 5. No adoption shall be made after the commencement of this act by or to a Hindu except in accordance with the provisions contained in this chapter, and any adoption made in contravention of the said provisions shall be void. An adoption, the clause 2, an adoption which is void shall neither create any rights in the adoptive family in favor of any person which he or she could not have acquired except by the reason of the adoption, nor destroy the right of any person in the family of his or her birth. This is section 5. Now let me kindly refer to section 6. The
Yes.
section 5 in the first clause itself makes it clear that if any adoption it is in contravention with the provisions entailed in this act, then the adoption is void in itself. It should be kindly refer to section 6. Requisites for a valid adoption. No adoption shall be valid unless the provision 4 would be relevant in my.
एक के बाद एक सब पढ़िए.
The person adopting has the capacity and also the right to take in adoption.
No problem.
No problem. The person giving in adoption has the capacity to do so.
No problem.
No problem. The person adopted is capable of being taken into adoption.
No
This
problem.
issue has not been dealt by the.
But otherwise you don't have any issues on that.
I
जो चीज डील नहीं किया है ना.
जो डील लेके अभी हम फ्रेश चीज ला नहीं सकते हैं at this stage ला नहीं
Roman
सकते.
4.
The fourth one, the adoption is made in compliance with the other conditions mentioned in this chapter. The other conditions which are very important is in 11, section 11.
Yes.
Other conditions for a valid adoption. In every adoption, the following conditions must be complied with. There is no scope, there is no room or scope for any sort of liberty. Clause 1. If the adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son, son's son, or son's son's son, whether by legitimate blood relationship living at the time of adoption.
This is complied.
That is not an issue.
Oh, that's not an issue.
Not an issue. This might become an issue अगर 2002 वाला चीज फिर consider
वो
किया.
तो बाद में देखेंगे.
Yes, Rich. If the adoption is of a daughter, the adoptive father or mother by whom the adoption is made must
So this
not
is
have
also
a.
you are not concerned.
No.
Okay.
I am
One, you
concerned
are
with
not
11.6.
concerned.
I am concerned with 11.6.
You come.
Your Leadership may straight away come to the 11.6 part.
Okay.
The child to be adopted must be actually given and taken in adoption by the parents or guardian concerned or under their authority with intent to transfer the child from the family of its birth, or in case of an abandoned child or a child whose parentage is not known, from the family or family where it has been brought up to the family of its adoption. It is of paramount importance. It is very incumbent that all the earlier previous ties of the adopted child has to be severed. There has to be nothing in existence.
That's right.
Leadership just refer the memo of appeal. The parentage
No, we
which
will not see with the memo.
he himself has signed as son of
Whatever
Saudagar
it
Rao.
is, you forget it.
Exhibit is
Come
also
to the finding.
Exhibit is also there. Exhibit at page 22, 24 and 26.
Exhibit.
हाँ.
Exhibit number.
Exhibit they are at page number. I have just seen the
Exhibit
record.
number. That's right.
C1.
You see, let us see what is the discussion of the courts. We are not going to reappreciate the evidence. We will go by the findings of the court.
It was brought on record the electoral ID of the present appellant. That is exhibited, which exhibits the natural guardian of the present appellant as the father, and that is till year 2004. Till 2004, he was having the same parentage. He is actually not residing. Leadership, voter ID is something which is made वो निर्वाचन के क्षेत्र के हिसाब से बनता है, depending upon your place of residence. His
वोटर आईडी कार्ड में कोई अपना राइटिंग में डिक्लेरेशन नहीं देता है. वोटर आईडी कार्ड जब बनता है, no declaration is given in writing.
but parentage is there,
Parentage would be there, but no declaration is given in writing.
residence is there, that is verified. That is a matter of fact. That is verified when a person's voter ID is being prepared. वो निर्वाचन क्षेत्र के अनुसार जो जहाँ पे स्थानीय रहता है वो वहीं बनता है. तो this voter ID is a conclusive proof that the earlier bonds of the adopted, so assumed as adopted child, was never severed. Lordship, I'll just
Voter ID exhibit. Exhibit.
C.
See, it was exhibited
वो
by whom?
appellate order में हुआ था.
It was exhibited by the plaintiff.
During the appeal it was exhibited.
At appellate stage.
Additional
They had brought additional
Additional-
evidence before the appeal.
Yes, Your Lordship.
Plaintiff's additional evidence.
Additional evidence.
At appellate stage.
Yes, Your
Was it allowed?
Yes, Your Lordship. That was allowed. Exhibited.
Which all documents were exhibited?
3 year Vedants. The list of निर्वाचक नामावली 2004 तक जो है उनका एग्जिबिट हुआ था.
This is basically relating to the
Electoral copy of voter list of district electoral
Copy
office. Copy of list from, it would be better.
list from
District election office, Dumka. This was brought on record.
just a moment. Duly proved. Duly proved.
Yes, sir.
Who proved?
Never objected.
It was marked with without objection.
It was not objected.
Appellate.
Now, leadership may kindly refer to.
Appellate. And where are these exhibits?
Your leadership, the internal page 16
Where are these
of the appellate
exhibits?
order.
Where do I find these exhibits?
Page 22 of the LCR, page 22, 24 and 26 of 3 different years.
This is not exhibit C, it is exhibit 3.
Oh, sorry, Your Lordship, I must be wrong. I
3,
apologize
3
for
by
that.
1 and
3
3
3 by 1, sorry. Your Lordship, it has been discussed at internal page 16 of the appellate order.
16.
Internal page 16,
Yes.
the last paragraph, Your Lordship.
Yes.
दौरान अपील I just seek permission to have a sip of water.
Sure.
दौरान अपील वाद के लंबित रहते अपीलीय न्यायालय के समक्ष प्रदर्श 3 अभिप्रमाणित प्रति 161 जामा विधानसभा निर्वाचन क्षेत्र की निर्वाचन सूची पेश की गई है, जिसकी क्रम संख्या 98 में पवन राउत द प्रेजेंट अपीलेंट पुत्र सौदागर राउत दर्ज है और क्रम संख्या 95 में सौदागर राउत, क्रम संख्या 96 में हरनी देवी का नाम दर्ज है. यह प्रदर्श ग्राम धनौर थाना नंबर 12 अंचल रामगढ़ पंचायत रामगढ़ जो पुनरीक्षण वर्ष 1995 से संबंध है.
This is revised list of 95.
अपीलार्थी वाद के ओर से प्रदर्श 3/1 निर्वाचन नामावली 2004 जामा निर्वाचन क्षेत्र पुनरीक्षण वर्ष 2004 ग्राम धनौर थाना नंबर 100 ग्राम कुशमाहा थाना नंबर 16 ग्राम जाड़ी थाना नंबर 17 पंचायत रामगढ़ ब्लॉक रामगढ़ अनुमंडल दुमका सदर से संबंध है, जिसके क्रम संख्या 110 116 में सौदागर राउत क्रम संख्या 111 हरनी देवी क्रम संख्या 112 16 में पवन राउत पुत्र सौदागर राउत. क्रम संख्या 113 16 आरती देवी पत्नी पवन राउत के नाम में दर्ज है। प्रदर्श 3/2 पंचायत निर्वाचन नियमावली 2010 प्रपत्र 4 से संबंध है, जो पुनरीक्षण वर्ष 2010 ग्राम पंचायत बड़ी रण वहियार, ग्राम कुरवा, थाना नंबर 13, ग्राम धनौर, अंश थाना 12, डाकघर बड़ी रणविहार, पंचायत बड़ी रणवहियार, प्रखंड रामगढ़, थाना रामगढ़ अनुमंडल दुमका सदर के अधीन है। और इस प्रदर्श के क्रम संख्या 398054 सो में सौदागर राउत, क्रम संख्या सो में हरनी देवी, क्रम संख्या सो में पवन राउत पिता सौदागर राउत, क्रम संख्या 402 आरती देवी पति पवन राउत दर्ज है। इस तरह से इन प्रदर्शनों के अवलोकन से दर्शित होता है कि प्रतिवादी प्रत्यर्थी पवन राउत का संबंध अभी अपने नैसर्गिक
At present.
हाँ, at present 2004 से लेके 10 तक
At present. Adoption deed 1975 का। The present में वो किसके साथ रह रहा है? किसको माँ बाप मान रहा है? It is not relevant.
No,
What
it is relevant.
What is relevant is in the year 1975 when he was adopted, whether it was acted upon.
No, it was not acted upon.
I want that finding that it was
That
never
is the
acted.
burden of, that it has to be proved by the person who is saying that I was adopted. There is a judgment over it.
Just. You say that it was never acted upon, right?
It was never acted upon.
Was that your case in the written statement? Was that your case in the written statement that it was never acted upon? This is a written statement. The entire case of the defendant is also mentioned in the written in the judgment itself, I suppose.
Yes, it was. Both the parties. The pleading of both the parties are.
Yes. So was that their case that it was never acted upon?
Your Lordship, even otherwise.
No, we'll come to that.
Yes.
Let him finish. The case of the defendant in brief. You read you read your own case that it was never acted upon. The case of the parties has been, you see para number 3, you read para number 3 of the trial court judgment.
The case of the defendant in brief, Your Lordship.
Yes.
The case of the defendant in brief is that the suit is not maintainable, having no cause of action for the suit.
You are the
suit-
plaintiff, no?
I am the plaintiff.
Yes. So you read your case.
Para 3.
You read your case.
That's the para 2.
Yes.
The case of the plaintiffs, in short, is that the plaintiffs and defendants are Hindu, governed by the Mitakshara law so and so. The plaintiff number 2 is the adopted son of Kukri at Chandan Kumar, taken in adoption by Shanti Kumarin. The plaintiff number 1 on 24/6/2002 in her residence in presence of villagers and relations given by Gopal Rai and Srimati Bimli Devi, the natural parents of the plaintiff number 2, on performance of Katha Puja in token of the aforesaid adoption of the plaintiff number 2 given by his father and mother and taken by Shanti Kumarin, and adoption deed was written and duly executed on 8/7/2002 by Shanti Kumarin and the natural parents Gopal Rai and Bimli Devi in the year 2002. The age of the plaintiff number 2 was only 4 years and was unmarried and is still unmarried, and the plaintiff number 2 was known as Bhagna, son of Shanti Kumarin. On such performance of the plaintiff number 2 was changed as Kundan Kumar, son of Kukri Kumar, from his original name Mittu Rai, son of Gopal Rai. Plaintiffs are living as natural mother and son. There was a criminal case number 1194 filed by Shanti Kumari against Amir Lal Kumar under section 144 in the court of SDM Dumka in respect of the land of Jamabandi number 8 of Mosa Dhanor. The said land of Jamabandi number 8 is recorded in the name of Guru Charan Singh in Ganjar settlement. The RT Guru Charan Singh died, leaving behind the only daughter Shanti Kumarin, who has been cultivating the lands and paying the rent regularly. In proceeding under section 144 CRPC, police submitted a report by which the plaintiff for the first time came to know about the false and fabricated claim of defendant number 1 as the adopted son of Chandan Kumar and Shanti Kumari, whereas the defendant number 1 is not the adopted son of Chandan Kumar and never taken in adoption by his widow Shanti Kumari, and nor any ceremony that regard was performed, and neither on 25/5/1975 or any date the defendant number 1 was given in adoption by the natural parents number 2 and 3, and the defendant number 1 is still living with the natural parents, defendant number 2 and 3. The marriage of defendant number 1 was also performed by his natural parents. In order to substantiate this claim of mine, the voter list of since 1995 till 2010, that is for 15 years, was exhibited. For all this long, which I could have procured, which the plaintiffs could have procured, they filed it. This was the case which was substantiated by the evidences produced at the appellate stage.
So your status post 1995. This was exhibited at the
status post 1995 was exhibited, but I never waived the claim. I never gave up this contention that at the time, even if assumed that the adoption was conducted, the son was ever handed upon to me.
Okay.
This was my contention. Now, Your Lordship, may I kindly refer to one judgment again on this particular point.
No, we'll come to the judgment. Let us see the findings first. What is the further finding of the appellate court in this connection? After having considered this, after having recorded that at present you are living with your natural parents.
Page 16 onwards.
Yes, 17. We are at
We are
page
now at 17.
Then he has considered exhibit B by 1, right? So on the basis of your status, on the based on electoral entries, he said that your the case of adoption has not been proved.
It has not been. It was never acted upon. The mandatory condition of 11th.
You are not able to get one thing, and which I am asking you for the last time. Adoption is of 1975. Electoral documents were produced, which from 1995. There is a gap of how many years?
20 years.
20 years. And the appellate court records that at present your status is this. This is a finding. अभी को हम लोग भूल नहीं सकते. We will just take care of that also, right? इस तरह इन प्रदोषों के अवलोकन से दर्शाते हुए कि प्रत्यार्थी पवन राउत का संबंध अभी अपने नैसर्गिक माता पिता के साथ. He is at present having relationship with his original parents or natural guardians. Then please refer to this. You read further.
I think that
You read further. Show me that finding that particular deed was never.
May I continue reading the
Yes.
same page? इस संदर्भ में प्रस्तुत प्रदर्श B1 का अवलोकन किया जाना न्याययुत प्रतीत होता है, जिसके मुताबिक मुस्मात शांति कुमारी द्वारा दिनांक 23/6/75 को सौदागर राउत व हरनी देवी राउतिन के बेटे पवन राउत को दत्तक पुत्र के रूप में ग्रहण किया जाना कथित है, मगर इस विलेख में पवन राउत के उम्र का उल्लेख नहीं किया गया है और दत्तक ग्रहीता शांति कुमारी की उस तारीख में उम्र 50 वर्ष की रही है, जबकि नियमानुसार जिस पुत्र का दत्तक के रूप में ग्रहण किया जा रहा है उसकी उम्र 12 वर्ष से अधिक की नहीं होनी चाहिए और दत्तक ग्रहण में जिसे दिया जाए वो दत्तक ग्रहण करे, इन दोनों के बीच में 21 वर्ष का उम्र का अंतर होना चाहिए.
Was it your case that at the time of adoption you were more than 12 years of age?
As per
Was that your case?
no, in
was
the
not
light
your
of
case.
Parrot 2,
So therefore this is irrelevant.
this discussion was known. This was never my point in the trial court. That's what no longer.
Next further.
इस विलेख पर प्रदर्श ए के रूप में हस्ताक्षरकृत राम निशान राय कराया गया है। इस विलेख पर हरनी राउताइन, सौदागर राउत और शांति कुमाराइन का अंगूठा है, जिसमें शांति कुमाराइन की निशानी अंगूठे का बहुत ज़्यादा महत्व है और यह कि निशानी अंगूठा शांति कुमाराइन का है या नहीं। इस संदर्भ में
just a moment. This exhibit A is, what is exhibit A?
The signature of Ram Nishan Rai on adoption deed,
Dated?
number 478 of 23/6/1975.
Oh, so this execution of this document is not in dispute.
हाँ, this
So therefore this is also irrelevant. कि उनका signature है कि नहीं है. Absolutely irrelevant. आगे बढ़िए.
इससे स्पष्ट होता है कि प्रतिवादी पक्ष द्वारा शांति कुमारिन के द्वारा विदय नीति से छल दगाबाजी करके यह विलेख तैयार किया गया है। वह विधवा अवस्था में असहाय किंकर्तव्य
नहीं,
विमूढ़।
आप एक लाइन लगता है हमसे छूट गया है। इस संदर्भ में प्रतिवादी प्रत्यार्थी द्वारा,
इस संदर्भ में प्रतिवादी प्रत्यक्षी पक्ष द्वारा इसकी जांच विशेषज्ञ से नहीं कराई गई है, न उक्त के संदर्भ में विशेषज्ञ का कोई प्रतिवेदन है जिससे ये कहा जा सकेगा कि यह विलेख शांति कुमारिन द्वारा निष्पादित किया गया, जिस पर उनका जायज निशानी अंगूठा दर्ज।
absolutely irrelevant, not born out of the records. आगे बढ़िए. इससे स्पष्ट होता है.
इससे स्पष्ट होता है कि प्रतिवादी पक्ष प्रत्यर्थी द्वारा शांति कुमारिन के द्वारा विदय नीति से छल दगाबाजी करके यह विलेख तैयार कराया गया है। वह विधवा अवस्था में असहाय किंकर्तव्य विमूढ़ निरुपाय रही है तथा प्रतिवादी प्रत्यर्थी गण उसके नजदीकी गोतिया हैं, जिनके द्वारा वादनी की संपत्ति को हड़पने की नियत से यह दस्तावेज निष्पादित कराया गया है, जो जाल फरेबपूर्ण है।
Forged and fabricated कैसे? Forged and fabricated नहीं है ना, because that is not a case.
No, that was not the case.
Then why this finding of forged and fabricated?
But
That is not a forged document. That was duly executed. Now the point is whether it was acted upon, cancelled or whatever.
that was
The execution of that deed is not in dispute.
the execution of the deed was not
Then
in
why this appellate court under what provision
On
of
the
law is
submission-
giving a finding?
on the submission that when I went to the registry for getting a Bhukat Batta land registered, I was not aware of the fact that on what paper my
No, you see,
thumbprint was being taken.
let us be there. He is doubting her signature, right? Saying that it has not been examined through an handwriting expert or whatever, any expert, and which shows that it is a forged and fabricated document. This is the sequence. This is the discussion.
That is not the one. Yoship, मैं just to again read the same line. इससे स्पष्ट होता
नहीं,
है
ऊपर से पढ़िए ना, किससे स्पष्ट होता है?
शांति कुमारिन की निशानी अंगूठे का बहुत ज्यादा महत्व है और यह निशानी अंगूठा कुमारिन का है या नहीं, इस संदर्भ में प्रतिवादी प्रत्यर्थी द्वारा उसकी जांच विशेषज्ञ से नहीं कराई गई, न उक्त के संदर्भ में विशेषज्ञ का कोई प्रतिवेदन है जिससे यह कहा जा सकेगा कि यह विलेख शांति कुमारिन द्वारा निष्पादित किया गया है, जिस पर उनका जायज निशानी अंगूठा दर्ज है।
Disbelieved the execution of the document.
Now coming to the finding part.
Yes.
इससे स्पष्ट होता है कि प्रतिवादी पक्ष द्वारा शांति कुमारिन के साथ विधेय रीति से छल दगाबाजी करके यह विलेख तैयार कराया गया है और विधवा अवस्था में असहाय किंकर्तव्य विमूढ़ निरुपाय रही है तथा प्रतिवादी ने स्वयं जिनके द्वारा वादिनी की संपत्ति को हड़पने की नियति से यह दस्तावेज निष्पादित करेगा। फॉर्जरी एट वो सिग्नेचर वाज नॉट इन क्वेश्चन। What the
We'll see that.
observation
We have
is,
read it. We'll see that. आगे पढ़िए. What do you want to say more?
इस संदर्भ में प्रतिवादी पक्ष की ओर से प्रस्तुत मौखिक साक्ष्य का अवलोकन किया गया है जाता है, जिससे प्रतिवादी सौदागर राउत प्रतिवादी संख्या 2 के रूप में परीक्षित हैं, जिनके द्वारा बयान तहरीर की अंतर वस्तु पर प्रकाश डालते हुए अपने मुख्य परीक्षण में कहा गया है कि संतान के अभाव में शांति कुमारिन दिनांक 20/5/75 को अपने गांव घर के समाज के लोगों के बीच सत्यनारायण का कथा पूजा करके इनके पुत्र पवन राउत को पोष्य पुत्र का लेन देन किया गया। उसका नाम रामचंद्र कुमार रखा। दिनांक 23/6/1975 को दुमका उप निबंधन कार्यालय में पोष्य पुत्र की दलील बनी, जो दलील संख्या 478 1975 के रूप में निष्पादित हुई, जिस पर साक्षी की पत्नी व वादिनी शांति कुमारी द्वारा अपना निशानी अंगूठा दिया गया, मगर न्यायालय के विचार में अभिलेख पर शांति कुमारी के निशानी अंगूठा की वैधता के संदर्भ में किसी विशेषज्ञ का कोई प्रतिवेदन उपलब्ध नहीं है। साक्षी का आगे कहना है कि दत्तक पुत्र रामचंद्र कुमार शांति कुमारी के साथ रहते चले आ रहे हैं, जबकि वादिनी अपीलार्थी पक्ष की ओर से प्रस्तुत प्रदर्श 3/1 3/2 निर्वाचन नियमावली यह इंगित कर रही है कि सौदागर राउत के बेटे पवन राउत सपरिवार अपने नैसर्गिक माता पिता के साथ रह रहे हैं। उनका शांति कुमारी से कोई वास्ता सरोकार नहीं है। इस तरह से ये प्रदर्श इस साक्षी के मौखिक साक्ष्य व दस्तावेजी साक्ष्य को नाजायज व झूठा करार दे रहे हैं। इस तरह इस साक्षी के साक्ष्य के जरिए वादपत्र में वर्णित अंतर वस्तु का खंडन प्रतीत नहीं हो रहा। So the final finding, it is a blend of two different things. The first one, the signature aspect was being considered. Let us consider that that is not very relevant. That was not the case. That this thumb impression is not of the present respondent. That was never the case as per para 2 of the trial court judgment. However, on the question of law, the 11.6, the mandatory condition of 11.6, in absence of which, in light of section 5 and 6 of the Act, the the adoption was never acted upon. It was void from day one, and henceforth it need not be challenged. The exhibits, though from year 1995 to 2010 were exhibited, but even the defendant in the title suit never brought on record any document from 1975 till 1995 in which his new name, let's assume that whatever is entailed in this particular paragraph is true, his new name or parentage is exhibited. For a valid adoption, the severance of ties, the breaking of earlier bonds is mandatory, and mere deed of adoption, just because the deed of adoption is existence, that does not mean the adoption has been given effect to. There are judgments which say that adoption deed is not sufficient. It has to be corroborated by other evidences which could indicate and conclusively prove that actual transfer of child did occur. Lordship, kindly refer to the judgment.
You have completed reading of the appellate court's judgment?
Yes,
You
sir.
completed. You don't need to read any further. The discussion is incomplete.
Yes, sir.
Your placing of the judgment is incomplete. You
No,
don't
no,
place it.
I'll be placing few judgments.
You complete placing of the judgment, then we'll come to the other judgments that you are.
Leadership, the next judgment I'll be citing is at page 70, serial number 11. Sita Bai versus Ramchandra,
Page number
70. It starts from page 70, 1969,
70.
2 SCC 544.
Yes.
And the relevant excerpts are at page 75. May I place that? It is clear on a reading of the main part of section 12 and subsection 6 of section 11 that the effect of adoption under the Act is that it brings about severance of all ties of the child given in adoption in the family of his or her birth. The child altogether ceases to have any ties with the family of his birth. Correspondingly, these very ties are automatically replaced by automatically replaced by those created by the adoption in the adoptive family. The legal effect of giving the child in adoption must therefore be to transfer the child from the family of its birth to the family of its adoption. The result is, as mentioned in section 1411, namely, where a wife, this is a discussion of that particular case, adoption by the husband results in the adoption of a child by both the spouses. The child is not the only child of the adoptive father but also the adoptive mother. In case of where there being two wives, the child becomes the adoptive child of the senior most wife of the marriage. The junior wife becomes the stepmother of the adoptive child. Even when a widower or a bachelor adopts a child and he gets married subsequent to the adoption, his wife becomes the stepmother of the adopted child. When a widow or unmarried woman adopts a child, any husband she marries subsequent to the adoption becomes the stepfather of the adopted child. The scheme of section 11 and 12, therefore, is that the case of the adoption by a widow, the adopted child becomes absorbed in the adopted family to which the widow belongs. In other words, the child adopted is tied with the relationship of sonship with the deceased husband and the widow. The other collateral relations of the husband would be connected with the child through the deceased husband of the widow. For instance, which means I skip a paragraph, just the last 4 lines would be again relevant.
Let's continue.
The true effect, and the 4th line from the bottom, the true effect and interpretation of section 11 and 12 of the Act of 56 therefore is that either of the spouses adopt the child, all the ties of the child in the family of his or her birth becomes completely severed, and these are replaced by those created by the adoption in the adoptive family. The terminology which has been used is completely severed, which means that even if in the year I am exhibiting a document of 1995, then also it should not have been in existence. Leadership, the second judgment again at page 78.
78.
Serial number 12.
Yes. Para number, please.
Para 37, page number 84.
Yes.
The very last line, Your Ladyship, at page 84.
Read para 37.
It was also pressed before us that the endorsement made before the sub-registrar would show that Venkatesh admitted the execution of the document before him. But in our view, the certificate regarding the registration is admissible for the purpose of proving that the document has been duly registered in the manner provided by the Act, and that the fact mentioned in the endorsement referred to in section 59 have occurred as therein mentioned. That is all. The mere fact that a deed of adoption has been registered cannot be taken as an evidence of proof of adoption, as an adoption deed never proves the adoption. The ratio of decisions Seth Birad Mal versus Sethani Pravavati Kumar so and so has no application to the facts in this case. The factum of adoption has to be proved by oral evidence or giving and taking of boy, and that the necessary ceremonies where they are necessary to be performed were carried out in accordance with Shastras. Para 38 is also relevant, Your Ladyship. Even then, an adoption deed which contains a recital as to the adoption having been made would not give the plaintiff a status of adopted son if the adoption itself is disproved, or this is my case from or when it is shown that the adoption deed was not executed voluntarily but was obtained by misrepresentation or fraud.
So, if it is obtained by misrepresentation or fraud, then under such circumstances, the misrepresentation or fraud is required to be proved.
Yes, Your Lordship, that has to be proved.
So, therefore, he has relied upon that judgment that whenever it comes to light that there is misrepresentation or fraud, that has to be challenged within a period prescribed from the date the misrepresentation or fraud comes to the knowledge of the plaintiff. That is the relevance of the judgment which he has cited. You respond to that judgment.
The 3 years cap
Not the 3 years gap. The judgment is that the day the misrepresentation or fraud comes into knowledge, 3 years commences from that date.
Indeed, Your Lordship, that does commence. What my submission would be that I have pointed out a judgment with respect to the illiteracy. She, to the best knowledge, she did made an attempt, though not exhibited, but it is a case, it was in the pleading, that she did something for cancellation of the deed. The second part was that since there is play of section 5, the same was not required to be challenged because it was never acted upon. So this entire process was never, it was void from the very beginning. The judgment which I have relied upon by in the case of
That I have understood.
that it had to be acted upon in absence of any action under 11 subclause 6. Section 5 makes the entire process of adoption redundant. And once it's redundant, it was never, it was not desirous for the appellant to, it should not have been challenged. It cannot be made mandatory.
The appellant, did they prove that it was acted upon?
The appellant? The present appellant?
Yes, the present appellant. Did they prove that the deed was acted upon?
No, they failed to do that. They never proved that.
There is no evidence on their part.
No,
No, they have said that some ceremonies were performed and
that has to be corroborated
by what?
by evidences,
Oral
by
evidence?
witnesses.
By witnesses.
Anything.
Did they produce any witness?
No, the witness was produced. The father was examined. That has been discussed in internal page 18, which I read of the appellate order. The father was only examined, and he said that the entire ceremony was conducted. It was convened, and thereafter the child was handed over.
Yes.
That was merely a statement.
No. It is an evidence only, oral evidence, because the performance of ceremony will only have an oral evidence.
Let us assume, just for the assumption, that the child was handed over to me. In what occasion, after 20 years, his voter ID is being prepared in the name of the natural father?
That is.
Had the ties which are mandatorily to be cut off from the natural guardian, there was no change in lineage. The present appeal which has been filed before your ladyship, the appellant, the present appellant, he is himself admitting that he is the son. The first page of the appeal may be kindly be referred to. He is referring himself as son of Saudagar.
He has no option because he has given the description as was there in the plaintiff.
So,
Because if you describe a person, son of such and such, so they have no option but to put it in that manner also. It goes like that only.
he had ample
All the party position goes along with whatever is described in
from the age which he has mentioned. I could deduce that at the time of adoption, his age must have been somewhat around 14 or 15. But at the time when
not your case.
No. I'm just placing one argument. In the year 1995, he got somewhat around 35 years of age. At 35, he had this sanity.
That is not the point on which you joined issues. That is not the point. That he was not of that particular age and therefore the adoption deed is invalid. That is not your case.
In order to demonstrate before the court of law that all the ties have not been severed, a lady who is not literate could produce only 3 documents of 15 long years in continuity that he himself is conceding that he is a son of Saudagar Rao. This is the best the lady could have done. And that is on record. I cannot argue on beyond the records.
What is the name of the adoptive child? Pavan Rao.
Pavan Raut.
You just see your exhibit. Exhibit 3. What is the age mentioned? 23 years.
Exhibit?
3. Saudagar Raut 23 years. So 95 he was 23 years.
I have exhibited till 2010.
I just want to know which is this document. Exhibit 3 is of the year 1995.
I'll have to verify the original records.
No, it is there.
It must be. I have seen in the morning.
95 में उनका अगर इतना ही एज का देखना है ना, because you did not join issues on that. This is what I am pointing out. Exhibit 3 shows that you are 23 years.
He was 18 above.
In 1995.
In 1985 he
So
was.
कितना हुआ 75 में age? You say that he was more than 12 years.
Proceed. I gathered this knowledge of his age by the memo of appeal.
So therefore, please do not argue this way, because that is
This memo he said
of
is
appeal.
50.
Whatever it is, you see, this is all matter of evidence. From memo of appeal, you cannot deduce anything. If you start talking about memo of appeal, then I will also then you will say that this age was not exhibited, isn't it? Exhibition of a document does not mean that this particular fact has been exhibited. He is shown to be 23 years in the year 1995. So please do not, that is why second appeal is not to be argued in this manner. You have to base it from the findings and the point in which the parties have joined issues. It was not your case in the plaint that he was more than 12 years of age on the date of adoption.
I never made
So,
that.
so please don't argue that. Any other judgment you want
Yes,
to
Your
place?
Lordship.
Which judgment is there that it need not be challenged?
No, again that will come in a renvo against me. That I am saying that particular document is not valid, then it need not be challenged. Then again this question will arise that how can you say that that is not invalid? There is no finding with respect to that. But if to that effect, I'll just place the judgment is at serial number 5, Prem Singh, 2006, volume 5, SCC 353. The relevant paras are para 11 and 16.
Just a moment. Prem Singh.
Yes, sir.
This is at page number 10?
Haan.
No, page number 15.
15.
Page number 15.
Para
would be
11 and 16.
Para 11 and 16. Yes.
Then your leadership another judgment at page 31.
No, ऐसे नहीं है. Place करिए जरा.
हाँ, place
बिना
करेंगे.
place किए.
Serial number 7.
You just place para 11 and 16. You place para 11 and 16.
Yes, sir. Leadership, I'm placing. This is on the point of limitation.
Yes, you read it. When you
Limitation
say para
is-
11 and 16, you read para 11 and 16.
Limitation is a statute of repose. It ordinarily bars a remedy but does not extinguishes a right. The only exception to the said rule is to be found in section 27 of the Limitation Act 1963, which provides that at the determination of the period prescribed thereby, limited to any person for instituting a suit for possession of his property, his right to such property shall be extinguished. Now we have leadership para 16. For when a document is valid, no question arises of its cancellation. When a document is void ab initio, a decree for setting aside the same would not be necessary, as the same is non-est in the eyes of law, as it would be nullity.
Para 17 also.
Once, however, a suit is filed by the plaintiff for cancellation of a transaction, it would be governed by section 59. Even if section 59 is not attracted, the residue article would. Limitation part is answered.
So limitation part 59 would be attracted.
Yes,
because you are
that would-
seeking a declaration that it is null and void. Now you come back to the limitation. Because that is a vicious circle you are stuck.
that is why I was saying कि round होकर के फिर I'll be starting from the beginning itself.
Yes.
This will
So
become a
this
vicious
judgment
circle.
you ought not have cited.
That is law. That
No.
is law. I cannot hide it.
All right.
The nullity point, I cannot read just one paragraph and another paragraph, I'll just suppress. That cannot be done. Now, your lordship may kindly refer to Judge serial number 7. Kishori Lal, 1958, SEC Online, SC 54.
This is at page number 24, 31.
31.
Which para are you referring to?
Para 7.
7. Yes.
As an adoption results in changing the course of succession, depriving wives and daughters of their rights and transferring properties to the comparative strangers or more remote relations, it is necessary that evidence to support it should be such that it is free from all suspicions of fraud and so consistent and probable as to leave no occasion for doubting its truth. Failure to produce accounts in circumstances such as have been proved in the present case would be very suspicious circumstance. So, the word which has been used is from free from all suspicion of fraud.
भगना था ना,
हाँ.
relation, close relation. ऐसा कोई stranger नहीं है.
If I may be permitted to place my case, just
No, I just, since
Ah.
relation, close relation is one of the aspects which has to be considered.
the only suspicion from the documentary evidences which have already been exhibited before the leadership, I can demonstrate only, the only point जहाँ पे I can raise a suspicion is that when the actual transfer was done, in what occasion, for 15 long years, he considered himself to be having ties with the earlier natural parents. He never exhibited any document, any school certificate. He could have done that. When this suit started way back in the year 2008, he could have done it. He never came up with any document, even the additional evidences he could have come. He never did it. The statement is only with respect to a ceremony. The judgment simple says that mere adoption is not a process on which has to be done on deed. There has to be transfer, and that transfer has to be vindicated by something. I have demonstrated, the present respondent has made out a case from exhibiting 3.3.1 and 3.2 that even after, assuming that the adoption was done, even after that, there were ties which were not severed. Hence, there is a violation of section 11.6, which further would make the entire adoption thing void from the very beginning in light of section 5. And since it was void from the very beginning, there was no transfer. In no occasion, the plaintiff would have thought to challenge the deed of 1975 within a period of 3 years. This is the entire case I'll be placing. Mind your lordship. Apart from compendium, I just got this one more judgment. बस इसमें एक paragraph है. The effect of adoption, how it should have been.
दीजिए वो judgment दीजिए.
At para 13. This has been discussed by the Honorable Supreme Court in the case of Akhela Lalita. Para 13 minutes. According to the Encyclopedia of Religion and Ethics, the adoption indicates the transfer of child from old kinsman to the new pool. The child ceases to be a member of the family to which he belongs by birth. The child loses all rights and is deprived of all duties concerning the natural parents. The words which have been used, that it should have all the ties should have ceased way back in the year 1975 itself. And the documentary proof on which I have put reliance,
Yes, continue.
on which I have put reliance, without any doubt clearly marks that there were existence of ties from 1995 till today. So the adoption could not have been said to be valid in light of the special conditions under 11(6) read with section 5 and 6 of the Act. Your Worship, that's the case.
That's all. I will record your response slightly later, just a few words, and then I'll record your response. The learned counsel for the applicant has referred to paragraph 2 of the trial court judgment to submit that the entire case of the plaintiff has been narrated therein. He has submitted that the specific case of the plaintiff was that the specific case of the plaintiff was that the defendant number 2 is a Mahajan of the locality, a property grabber who is very clever, fraud and litigant person. The plaintiff number 1 and the defendants had come to Dumka Registry Office on 25/6/1975 for execution of Bogot Bandha deed, but with the view to grab the land of said Shanti Kumarin. The defendant number 2 fraudulently manufactured a deed of adoption in favor of his son Pavan Rao. After some time, the defendant number 2, Saudagar Rao, told the plaintiff Shanti Kumarin about the adoption deed, and on inquiry, the plaintiff learnt about the matter on 18/8/1975. Then the plaintiff executed a deed of cancellation of adoption deed numbers 478 of 1975, dated 23/6/1975, before the Registry Office, Dumka. The cause of action for the suit arose on 12/9/2007, the date on which the defendants claimed adoption before the police officer of Ramgarh. The LS deed number 478 of 1975. The defendant's adoption deed is forged, so the suit be decreed. The learned counsel, while referring to the same passage, has submitted that it was a case of the plaintiff themselves that they came to know about the deed of adoption at least on 18/8/1975, and they had also executed a deed of cancellation of the adoption. But apart from that statement, no such deed has been exhibited before the court. अब इनका submission लिखिए. The learned counsel appearing on behalf of the appellant, on behalf of the respondent plaintiff, has submitted that the plaintiff claimed that the plaintiff had taken the plaintiff number 1 had taken plaintiff number 2 Kundan Kumar by way of adoption on 24/6/2002 after completing certain ceremonies. he has also submitted that the plaintiff number 1 is an illiterate lady and has no knowledge of law and procedure, and therefore merely because the earlier deed of adoption executed in the year 1975 was not challenged is not fatal to her case, particularly in view of the fact that it was her specific case that the deed of adoption of 1975 was executed by fraud committed by the defendants. He has referred to the judgment passed by Honorable Karnataka High Court, reported in 1997, SSC Online Karnataka 215, Ravi Namdev Kavale versus Kittaswamy, and has referred to the short judgment to submit that on account of that economic and other disabilities like illiteracy is also a disability, and consequential ignorance of law of limitation as such can be said to be a disability. And in the matter relating to right of a person to approach a court to obtain legal relief, unless malafide shown or established simply on ground of ignorance of lack of knowledge of law of limitation or like, no person should be punished for delay in filing the case. The Learned Counsel has submitted that the remedy was not barred by law, even if it is said to be barred by limitation. In view of the status of the plaintiff, who was completely illiterate and ignorant. The Learned Counsel has further submitted that without the Learned Counsel has also submitted that mere execution of deed of adoption is not sufficient. The same is also required to be acted upon in such a manner that the adopted child severes all his relationship with the natural parents. He has submitted that at the appellate stage, 3 documents were exhibited, that is exhibit 3, 3/1 and 3/2, which were relating to the records of the electoral office relating to the year 1995 till the year 2004, to submit that the defendant number 1 has been showing himself as son of his natural parents. He has submitted that a finding has been recorded by the appellate court on the basis of the additional evidence adduced before the appellate court that the defendant number 1 was living with his natural parents. The Learned Counsel submits that the said documents were enough to show that the defendant number 1 had not severed all relationship with his natural parents, and therefore the deed of adoption by itself, though it was said to have been executed way back in the year 1975, is of no consequence. He has relied upon the provisions of Section 5, Section 6 within bracket 4 of Hindu Adoption and Maintenance Act
5
1956.
subclause 1.
Okay. Section 5 within bracket 1 of Hindu Adoption and Maintenance Act, read with Section 6 within bracket Roman 4 and Section 11 within bracket Roman 6, to submit that the so-called adoption was no adoption in the eyes of law and it was void. The Learned Council has
And section 12 you read. 12 as well.
12 क्या है?
Effects of adoption.
And Section 12. वो भी डाल दूँगी. The Learned Council has further referred to the judgment passed by Honorable Supreme Court reported in bracket 2006 bracket close 5 SCC 353, paragraph 11 and 16, to submit that when a document is valid, no question arises for its cancellation. But when a document is void ab initio, a decree for setting aside the same would not be necessary, as the same is non-est in the eyes of law, and it would be a nullity. The Learned Council submits that the adoption claimed way back in the year 1975 is ex facie a nullity in the eyes of law, and therefore the suit cannot be said to be barred by limitation. However, during the course of arguments, para 17 of the said judgment is also relevant, wherein it has been held that once a suit is filed by a plaintiff for cancellation of a transaction, it would be governed by Article 59. Even if Article 59 is not attracted, the residuary article would be. The Learned Council has thereafter relied upon the judgment passed by Honorable Supreme Court reported in 1984 bracket close 2 SCC 337 para 7 to submit that as the adoption results in change in the course of succession, the adoption to strangers or more remote relation is required to be considered, is required to be examined as to whether it was free for any suspicion. He has also relied upon the judgment reported in AIR 1969 bracket close to SCC 544 para 5. To submit that the scheme of that the provisions of section 11 and 12 of the Hindu Adoption and Maintenance Act has been duly considered, and it has been held that the true effect and interpretation of section 11 and 12 of the Act of 1956 is that when either of the spouse adopts a child, all the ties of the child in the family of his or her birth becomes completely severed, and these are all replaced by those created by the adoption in the adoptive family. The learned counsel thereafter has relied upon the judgment passed by Honorable Karnataka High Court in the case reported in 1967, SCC Online Karnataka 144, Govinda versus Chimabai, para 37. To submit that in the state case also, to submit that in the state case, the endorsement was made before the sub-registrar, which showed that the document of adoption was executed, but it has been held that mere registration is not sufficient and cannot be taken as an evidence of proof of adoption, as the adoption deed never proves an adoption. It has been held that even then, an adoption deed which contains a recital to the adoption having been made would not give the plaintiff a status of an adopted son if the adoption itself is disproved, or if it is shown that the adoption deed was not executed voluntarily but was obtained by misrepresentation or fraud. The learned counsel submits that in the present case, it was a specific case of the plaintiff that the adoption deed was obtained by fraud. That's all.
And it was never voluntarily executed by the
And it was
defendant.
never voluntarily executed by the plaintiff.
By the defendant. Defendant could have also executed.
Execute तो defendant तो उस समय
It was never, sorry, it was not voluntarily ever executed by any of the parties.
अब बताइए आपको क्या बोलना है? So far as other issues are concerned, they are irrelevant. There are other points of law framed.
They all have been answered.
You
In
answer all
totality,
of
there
them?
were 8 questions.
No, only 3 questions.
Para 4 of a trial court judge.
No. The questions of
Substantial
law
question.
formulated by this court. If you don't address, we'll say that you have not addressed. Three has been addressed. What about 2? He has been made a party.
He has been made a party.
So it is irrelevant. I do not know, you say? What do you have to say with respect to substantial question number 2?
Just a second, I will go. I believe that while answering question number 3, some parts of the question number 2 have already been answered, and there are no further points I'll be raising to that effect.
No. Question number 3 is not related to question number
The
2.
question number 2 says
1 and 3 are related.
whether the learned first appellate court failed to consider the fact that plaintiff number 2, who was the second adopted son, could not have been arrayed as such when the plaintiff number 1 was making the prayer for cancellation of adoption of defendant number 1, and the plaintiff number 2 has no other right except that he is the adopted son. During the course of argument, I just pointed out that if 1975 deed is upheld, then the second one becomes redundant. That's it. Apart from that, there is nothing.
The learned counsel for the respondents has submitted that so far as substantial question of law framed number 1 and 3 are concerned, they are related. And he has advanced his argument on that. So far as substantial question number 2 is concerned, the point essentially relates to the fact that the plaintiff number 2, there was no occasion to array plaintiff number 2 as a party, as plaintiff number 2 was said to have been adopted by adoption deed of the year 2002. He has submitted that if the adoption deed of the year 1975 is held to be null and void or illegal, then under such circumstances, the adoption deed of plaintiff number 2 would survive.
Yes, Your Lordship. And in the title suit, he was represented in representative capacity by the plaintiff herself.
He submits that the legality of the adoption of plaintiff number 2 was also involved in this matter,
Yes, Your Lordship.
and he was being represented through plaintiff number 1.
Yes, Your Lordship.
Yes, Your Lordship, one of his argument is that the adoption deed was a void document and therefore it was not required to be cancelled. So my argument would be that
Yes.
this argument is falsified from the two facts that if it was a document which was not required to be cancelled, then why did she execute a cancellation deed in the year 1975 itself? And then she also files a suit for cancellation. So therefore this argument cannot be made. This argument could have been made by a defendant who did not file any suit for cancellation because under the impression that it is a void document. Then this could. A person who is himself filing a suit for cancellation cannot say that it was not required to be cancelled. And particularly when the lady herself in 1975 itself, she executes a cancellation. So that cause arose in the year 1975 itself and therefore she executed a cancellation. Now what would be the effect, Your Lordship? Another judgment I will be relying upon. Once the time starts to run, there is absolutely no stopping.
It's seamless.
So there is Khatri Hotel, Your Lordship may see this.
No,
Your
we
Lordship
don't
must
need
have
that
gone
judgment.
through.
It's
It says
well
that
settled.
successive violation of any would not give a fresh cause of action to the. Now here
Give me
the
that judgment.
yes, the judgment is 2011 volume 9 SCC, page 126. So while interpreting Article 58, the Article 58 word used is when the right to sue first accrues to the plaintiff, then he is required to file a suit within 3 years from the date when the right to sue first accrues. Here also in
This is
59,
with respect to Article
Article 58.
58.
58 says with regard to declaration, only declaration. And 59 is for cancellation, where the person is seeking cancellation. But in both the articles, the word first has been issued.
That's right.
Yes. So while interpreting Article 58, the Honorable Court says, Your Lordship may take this. It would be only
We are concerned with 59 only. But
59,
in
but
this judgment, 58 has been issued.
58, yes. But this would apply to 59 also.
Okay.
Para 23 onwards, Your Lordship may see. We shall first consider the question whether the suit filed by applicant number 2 was within limitation and the contrary concurrent finding recorded by trial court and the high court is legally unsustainable. The Limitation Act so and so prescribes the time limit for all the conceivable suits, appeals, etc. Section 2J of the Act defines the expression period for limitation to mean the period of limitation prescribed in the schedule for suit, appeal and application. Section 3 lays down that every suit instituted, appeal preferred or application made after the prescribed period shall, subject to the provisions of section 4 to 24, be dismissed even though the limitation may not have been set up as a defense. If the suit is not covered by any specific article, then it would fall within the residual article. In other words, the residual article is applicable to every kind of suit not otherwise provided for in the schedule. Article 58 says so and so, then Article 120 says so and so, and then Article 58, Your Lordship may see when the period begins to run is when the right to sue first occurs.
Para 30. You want to place para 30 as
Yes, yes.
23.
So it says after discussion, while enacting Article 58
I read
of the
it.
yes.
आप जब पढ़ रहे
हाँ.
थे.
So therefore successive violation, their right to file a suit arose on the date when they came to know about the suit on that date. Now second,
Yes.
now my argument would be whatever argument has been advanced, all those are on merits. If the suit itself was not maintainable because it was barred by limitation, then the court even cannot go into the merit, whatever may be the merit of the matter. No question of consideration of the matter on merit.
लाइव लॉ में 3 दिन पहले ही जजमेंट आया इसमें,
अच्छा,
नहीं देखे?
नहीं,
मत देखिए आप लोग।
नहीं, that is for condonation of delay.
Yes, then there is no question of any
Yes.
limitation.
But here, Your Lordship,
Suit is
interestingly, there is absolutely
So
no
we will
power
have
to.
we will have to consider all his
Yes.
arguments.
But
As
here
any
there
other
is a
person.
difference. Whatever judgment he has relied, that Karnataka judgment is where the appeal was filed belatedly, where there was a power of condonation. But there is absolutely no power vested with the court to condone the delay in filing the suit.
That's- we take-
Absolutely no power.
Anyways,
So therefore,
so anything else?
yes.
पूरा re-argue मत करिए।
Last. नहीं, 15 section 15 and 16 of Hindu Adoptions and Maintenance Act में kindly visit.
15 and 16.
15 and 16.
What is it?
It says two things. A thing which has already been done. 16 is the presumption. Presumption as to registered documents relating to adoption. Whenever any document registered under any law for the time in force is produced before any court purporting to record an adoption made and is signed by the person giving and the person taking the child in adoption, the court shall presume that the adoption has been made in compliance with the provisions of this act until and unless it is disputed. So there is an adoption deed, and we have also laid evidence that giving and taking ceremony was there. So therefore there is a presumption, and document is required mandatorily to be cancelled if she was actually affected by the document. And 15, Your Lordship may see, valid adoption not to be cancelled. No adoption which has been validly made can be cancelled by adoptive father or mother or any other person, nor can the adopted child renounce his or her status as such to return to the family of his birth. So my argument is that once the adoption was made and it was completed, any subsequent action would not undo the adoption which was already completed. So a fact which is there in voter
It is
ID of
something like if a
95.
minor is taken in adoption,
Yes.
upon attaining the age of majority, he cannot say that no, I will now come back to my
Yes.
parents.
Yes.
That is not permissible.
Yes,
But this
that
is too harsh.
And
But this is
absolutely,
it.
absolutely. Where he would go then?
That's
And last is that the appellate court and my learned friend, they are
it means
making
that
out a third case.
he has got no voluntary choice.
Yes.
If
And
if two parties are ready,
he
is treated as a chattel
absolutely.
till 12 years of age. He can be passed on to anybody with consent.
Yes.
Right?
And last is the
अजीब नहीं
appellate.
है?
एक लास्ट है.
अजीब नहीं है?
हाँ, ये तो अजीब है. ये अब इसका कोई ये नहीं है.
दो
But-
पेरेंट्स, दो अलग-अलग
हाँ,
पेरेंट्स
ये-
मिलके
ये-
एक बच्चे को जहां से मनो उठा के डाल.
This is a new aspect which I have not thought of. But this is although strange, but now,
But it is that only.
now last is that the appellate court and my learned friend, they are making out a third case which was not even in pleading. In their pleading,
But they have said, they have pointed
Absolutely.
out that it was a case that it was not acted on.
yes. So
They have made out, they have said so.
Yes.
I asked them also, and they have pointed out that. So this submission of yours is not correct.
So this was because the appellant has the appellate court has made out a third case. I'll be relying on Bachraj Nahar case
The
where
appellate court has not made out a third.
has made out.
No, appellate court has seen the additional evidence and has made out a case that post 1995 at least, at present, whatever finding has been recorded, he is living with his own parents. and he has declared himself to be the son of such executor. 1995 till 2004.
Execution was not denied by
No, that we
Shanti
have seen,
Kumari.
but
Then
they
also
have,
he,
appellate court has not made out a third case.
what he says, then also he goes into the question that she had not voluntarily executed, she was illiterate
Oh,
lady.
those things,
all
those things are irrelevant.
So,
He also admits that those
absolutely.
things are irrelevant.
So
Those discussions are irrelevant. That
That
there
is-
was no examination of handwriting expert, etc. Those are irrelevant.
Therefore, that is the third case which he is making.
That's all.
That is.
The learned counsel for the appellant in response has submitted that the respondent has made out a case during the course of argument that the deed was not required to be cancelled as it was null and void. However, such a point is not available as the suit was filed by the plaintiff seeking cancellation of the deed, and therefore it has to be governed by the provisions of the Limitation Act. Article 59 is impacted. He has also referred to the judgment passed by the Honorable Supreme Court, reportedly bracket 2011, bracket close 9 SCC 126, and has submitted that the same judgment has been delivered in the context of Article 58. But the same principle would apply. The learned counsel has submitted that the cause of action to file the suit arose when the first cause of action was there. He has relied upon paragraph 23 and 30 of the same judgment. Yes, he submits that subsequent cause of action will not give rise to fresh period of limitation. The learned counsel has also submitted that once the suit is held to be barred by limitation, then there is no question of giving any findings on merit. The learned counsel has also submitted that the appellate court has gone into and made out a third case altogether by observing that the lady was illiterate and there was no comparison of this, and her thumb impression was not sent for examination by expert, although the execution of the deed was not in dispute. And the case of the plaintiff was that it was fraudulently got executed. The learned counsel submits that it is not permissible for the court to make out a third case which was not, on which the parties did not join issue. He has also submitted that section 15 and 16 of the Hindu Adoption and Maintenance Act 1956 is required to be taken into consideration with regard to validity of adoption and presumption as to registered document relating to adoption. He has submitted that not only the execution of the adoption deed was duly proved, but also the ceremonies in connection with the adoption was also proved by the defendant. That is all.
Yes.
So far as issue number 2 में क्या बोलना है आपको? The learned counsel has also submitted that the exhibit 3/1 and 3/2 exhibited at the stage of the appellate court has no relevance in view of the fact that once the child is adopted, he cannot go back to his natural parents. Or that's all.
That's all. But
Second के बारे में
only to answer question number 2. Your Lordship, plaintiff number 2 was the adopted child who was claiming through adoption
Subsequent.
deed of the year 2002.
Two.
So my submission was that he could not have challenged the earlier deed which was executed in the year 1975. It was only plaintiff number 1 she could have challenged.
The learned counsel for the appellant has submitted that so far as plaintiff number 2 is concerned, the he came into picture in view of the fact that there was a deed of adoption with respect to him in the year 2002. He submits that plaintiff number 2 could not have challenged the adoption which had taken place way back in the year 1970.
Yes, yes.
Fine. So 2002 में इसका कितना उम्र?
Therefore,
He was born in 1975.
No, therefore,
He was not
No,
born
he
in
was already
1975.
No, 10 years.
तो 75 में तो जन्म भी नहीं हुआ था इनका.
नहीं हुआ.
सारा
4
कहानी
years.
वही है.
He was shown as minor in the suit.
In 2008, he
In
was 10
2000.
years.
It is submitted that in the year 2008 he was just 10 years of age as shown in the plate itself, and therefore he was not even born in the year 1975 when the adoption had taken place.
Yes.
The plaintiff number, the defendant number 1 is the Bhagna. क्या relation है?
कोई relation तो
है कहीं
कहीं पर आया था.
Bhagna ही है. Anyways, the learned counsel has also submitted that so far as the judgment passed by Honorable Karnataka High Court reported in 1997 SCC Online Karnataka 215 is concerned, the same was relating to filing of appeal where there is a provision for condonation of delay, but so far as suit is concerned, once a suit becomes barred by law, barred by limitation, there is no remedy enforceable through the court of law.
And it cannot be condoned. And the delay cannot
And
be.
delay cannot be condoned. आज कितना? आज Tuesday है ना? Tuesday. Pose for judgment on Friday. Argument is concluded.
Bishop Karnataka High Court का citation क्या है?
सारा कुछ इसमें है. सारे पैराग्राफ्स आप अपने जो एडजमेंट ऑर्डर्स हैं देख के समझ के सारा मार्क है वो सब गोलाई जी को बोलकर सारा ऑर्डर में लगा देंगे जिससे हमको लिखने में दिक्कत हो. ठीक है. और आर्टिकल 58 एंड 59 दोनों को कोट करना है. फ्लैग किया हुआ है पेज नंबर 21 में. हिंदू अडॉप्शन एंड मेंटेनेंस एक्ट का जो जो सेक्शंस इन्होंने रेफर किया है उसको कोट करना है. ये लीजिए. ये ना एक रेस्पोंडेंट का एक जजमेंट लिख गया था इसका पैराग्राफ वो हम करते हैं.
This case from daily list item 2 for final disposal, second appeal 110 of 2017.
Yes, respondent, you are there. In this case, the trial court has disbelieved both the reports,
Yes.
isn't it? Correct? Correct or not correct?
That is there.
No, let us be very clear on facts. The trial court has rejected both the reports of the pleader commissioner. One was who was appointed by the court, the other who was appointed by the plaintiff. दोनों को रिजेक्ट कर दिया. लेकिन एपेलेट कोर्ट क्या लिखते हैं? एपेलेट कोर्ट क्या लिखते हैं? एपेलेट कोर्ट का जरा देखिए.
Appellate court has come to the finding.
नहीं एक सेकेंड.
Appellate court का है वो जो paragraph.
एक इंटरनल पेज 13 में देखिए. इंटरनल पेज 13 ऑफ द एपेलेट कोर्ट जजमेंट. Further I find, ये देखिए, further I find appellate court judgment almost at the middle जहाँ schedule A भी लिखा हुआ है. Further, I find पढ़िए जोर से पढ़िए. Further, I find पढ़िए please read it. इनको बताइए आप ठीक ही पढ़ रहे हैं.
Further, I find much substance in submission of the appellant that learned court below has wrongly relied upon the report of Survey Knowing Commissioner Nageshwar Prasad Sinha, who was not appointed by the court and illegally discarded report of Survey Knowing Commissioner Narayan
This is
Rai.
not correct. ट्रायल कोर्ट ने दोनों रिपोर्ट को रिजेक्ट कर दिया.
बोर्ड में किया हुजूर, लेकिन action meant the report was relied upon submitted by Nageshwar Prasad by accepting the measurement of land, that a strip of land was actually existing. Your lordship will kindly
आप ट्रायल कोर्ट का जजमेंट से दिखाइए कि ये इस पर्टिकुलर रिपोर्ट को रिलाई किया है. The trial court has relied upon oral evidences to come to a finding after discarding both the reports. जो हमको समझ में आया, और अगर गलत समझ में आया तो समझाइए.
that is the observation of the court.
No, not
But the
the
finding arrived at by the trial court was on the basis of the report submitted
No,
by Nageshwar
was on
Prasad.
the basis of oral evidences.
Oral evidence when the document is there, my lord.
See,
The oral
मेरा ये
evidence has got no evidentiary value, my lord.
No. Both the reports were discarded by the trial court. Both the pleader commissioner
Even-
report is not binding on the trial court.
Even if it is admitted, my lord, that the trial court discarded both the report, my lord.
Yes. Then this finding is
my lord,
erroneous.
then there was no occasion for the trial court to disbelieve the report of measurement. Actually, therefore, on the last date, I was seeking permission of this honorable court to read the report of the, my lord,
No, we will
pleader
see.
commissioner.
You see, let us be very clear on facts.
Hello.
There were two reports.
My lord.
Now you tell us whether the trial court has the jurisdiction to reject the report or not.
That is there, my lord.
That is there.
That is there, my
There
lord.
is no doubt on that.
There is no doubt in it.
There are two reports,
There are two reports.
and whether the learned trial court has rejected both the reports or not.
He has written in the judgment
Yes, that he rejects both the reports.
both reports are not acceptable.
Acceptable. Therefore, this particular discussion of the appellate court
My lord.
that the commissioner report of the court was wrongly rejected and the private report was taken into consideration is also not correct.
That is
Because
not-
the learned trial court had rejected both the reports. So this is an error of record.
Then there is an error.
Okay. This is an error
That
of
is-
record, right?
My lord,
Okay.
this much is admitted.
Now you tell
My
us.
lord, one more thing, my lord.
क्वेश्चन ऑफ लॉ में आप कन्फाइन करिए, ठीक है? पढ़िए क्वेश्चन ऑफ लॉ एक बार और.
Then by this one,
Yes. By the order dated 15/3/2024.
whether the learned appellate court, while reversing the judgment passed by the learned trial court, was justified in not considering and meeting the reasons given by the learned trial court to declare this.
और B.
Whether the learned appellate court was justified in not considering any oral evidence adduced by the party.
Now let us come to point number B first. Is there any discussion of any oral evidence by the appellate? Is there any discussion? कोई भी discussion है?
That is, there is no minute discussion.
No
of the
discussion.
oral
Okay.
evidence. There is no.
Was there any requirement of any discussion?
Discussion. When the order was being set aside, my lord, it ought to have been discussed.
It should have been
Ought to have
discussed.
ought to have been discussed.
And further, the findings of the learned trial court, is it based on oral evidence?
Only oral evidence.
Only oral.
Only oral evidence.
That's right. Therefore, in such circumstances, where there is a judgment of reversal,
Hello.
and the trial court,
Because I may be permitted to say, because the crux of the problem lies in the identification of this suit land. An area of 69 decibel was purchased, Exhibit 6 may kindly be taken into consideration. And what I had submitted on the last date before
आप
your
प्लीज
lordship,
रिपीट करेंगे.
my lord, my lord.
कल जो उस दिन जो सबमिट किए थे थोड़ा उसको समरी रिपीट करें.
हुजूर उसको रिपीट कर रहे हैं हुजूर हम.
हाँ.
I had submitted before your lordship that a single piece of land cannot have two separate boundaries. The land purchased by the plaintiff finds mentioned in the deed which has been marked as Exhibit 6. From the perusal thereof, your lordship will find that it contains a single boundary. Whereas from the reading of the plaint,
This is Exhibit 6.
my lord, from the reading of the plaint, your lordship will find that the land purchased by the plaintiff find mention in Schedule A and Schedule B with separate boundaries.
Just Exhibit 6 निकालते हैं पहले.
Exhibit 6, हुजूर.
हाँ निकाल. Exhibit 6 is dated.
हुजूर.
Date क्या है Exhibit 6?
69 का परचेज है हुजूर.
Schedule A और Schedule B पढ़ें, उसके बाद 69 का परचेज है.
हुजूर. तो प्लेंट में है
हाँ पढ़िए पढ़िए.
हुजूर. Schedule A, land and structure purchased by the plaintiff from Bihar Mines Limited under the registered sale deed dated 4/11/1968. Page 5 of the plaint panel.
हाँ yes.
All the piece and parcel of land being part of plot number 669 together with building and structures thereon containing an area of 77 decibels situated in village Isri, Thana Dumri, district Hazaribagh, bounded as follows: North GT Road, South plot number 677, East House of Dhanesar Saab and Nagari, West plot number 677. Now the area does not find mention here. Schedule B, a strip of land. That is my point for submission and consideration before this honorable court. A strip of land measuring 14 feet 6 inch by 24 feet with brick compound wall towards east, west and south, including a small house over a portion of it, being a portion of plot number 669. 669. Within Khata number 29 of village Isri, PS Dumri, district Giridih, having the following boundary: Granton Road, gate and compound wall of the plaintiff, house of the defendant, house of the plaintiff in occupation of their tenant Chotelal Barnwal.
And they
My
claim
lord.
that They claim that Schedule B is a part of Schedule A, as per the plaint.
They are, but they have given two different boundaries. Number
No,
one
no.
and number two, my lord.
भाई,
There
एक
no,
सेकंड आप जरा देखिए इसमें एक बाउंड्री तो
no
common है.
such a specification. Entire case of the plaintiff rests on Schedule B land.
Schedule, their cases that
Schedule B land, my lord. But
आप मेरा
neither.
बात तो सुनिए.
The,
As per their case, Schedule B is a part of Schedule A.
well, maybe, my lord, I cannot deny that is there. But the specification
Okay.
that a strip of land measuring such and such area situates, and unfortunately, my lord, this Schedule B land was not framed to be as an issue by the trial court. Only Schedule A land kindly have, my lord. The issue was not framed with respect to Schedule B land by the trial court. Only Schedule A land was mentioned there.
The appellate court framed the issue with respect to Schedule B land.
My lord, the appellate court did not frame the issue, but the appellate court came to the finding
What?
that this strip of land mentioned in the plan was not proved by any substantive evidence, oral or
Without
documentary.
framing any issue.
My lord,
Without framing any issue to this effect.
without framing issue. Issue was not framed by the by the appellate court,
so
my lord.
according to you, even the appellate court has not dealt with property.
Not done.
Therefore,
They
under
have
such-
decided the issue without framing it the same.
So therefore, what is the remedy? The matter has to go to the appellate court. Isn't it? भाई सेकेंड अपील में तो हम पहली बार इसको इशू फ्रेम करके नहीं डिसाइड करेंगे ना. The matter has to go to the appellate court, because appellate court, for two reasons. Firstly, you say that no specific issue was framed with respect to this, but a finding has been recorded that Schedule B could not be proved to be a part of Schedule A, right? And there is no discussion of oral evidence, right? Therefore, under such circumstances, we are not here to decide the facts for the first time. This exercise has to be done
And
by
I
the
have
appellate
also
court.
gone some judgment passed by this honorable court where the similar view has been taken.
Yes, so this has to go. We can't help it. रिवर्सल में आप फाइंडिंग नहीं देखेंगे, आप कुछ नहीं देखेंगे, डिस्कशन नहीं करेंगे, तो कैसे ही क्या होगा बताइए. डिमांड कर देते हैं, डेट आप जो बोलिए फिक्स कर दो. चूज योर डेट व्हेन यू वांट टू बी देयर. ठीक ठीक है, ये कर देते हैं. These are the two issues which are to be decided, और ये कर देते हैं.
शूट लैंड ही वही है.
देखिए उतना हम कुछ नहीं बोलेंगे. I will simply say that if any additional issue is to be framed by the appellate court, the parties, it's open to them to get the issue framed. इसके beyond कुछ बोलने का हमको जरूरत नहीं.
My lord.
ठीक है ना? देखिए. Second appeal number 110/2017. This appeal was heard.
My lord has passed judgment
हाँ,
on this
yes.
issue. One of my case.
आप ही का तो केस था उसमें.
All those judgments are referred here. Those judgments
Yes,
are
संग्राम दास की बात होती है. वही तो हम भी रखे हुए हैं.
28 वाला ना.
उजुरी का जजमेंट है.
हमको जो जजमेंट प्लेस हुआ, तो विद्वान अधिवक्ता ने प्लेस किया जजमेंट, हम सोचे कि एक माइंड अपना फ्रेम कर लें कि एपलेट कोर्ट अगर ये
डिस्कस
नहीं
किए हुए
करता.
हैं उजुरी, इसलिए ही रखे हुए जजमेंट हम के उजुरी का ही ओपन है माइंड इस पर.
ठीक. ऐसे नंबर 110 of 2017. This appeal has been admitted on 15/3/2024 on the following substantial questions of law.
वो
इसकी
सब referred
जरूरत
judgment.
नॉट रिक्वायर्ड, ये सारा रेफर्ड है इसमें. The learned counsel for the appellant has submitted that the suit was filed with a prayer for declaration that suit B land belongs to the plaintiff and he has title over the same, and plaintiffs be put in possession of Schedule B property. He has submitted that it was the specific case of the plaintiff that Messrs. Bihar Mining Limited had acquired the land and structure mentioned in Schedule A by the registered sale deed dated 18/10/1954 and by virtue of registered sale deed dated 4/11/1968, the plaintiff had purchased 77 decimal of land together with structure thereon, being portion of plot number 669 within Khata number 29 of village Isri PS Dundri, besides other lands in other plots from Messrs. Bihar Mines Limited. The property so purchased, the land and structures purchased by the plaintiffs within plot number 669 was specified in Schedule A of the plate. It was their further case that a strip of land measuring 14 feet into 6 feet, 14 feet 6 inches into 24 feet described in Schedule B was part and parcel of 77 decimal of land purchased by the plaintiff from Messrs. Bihar Mines Limited under registered sale deed dated 4/11/1968. The said land was adjacent to south of GT Road and in front of the iron gate fixed in the northern compound wall of the plaintiffs. The land was described as Schedule B. The learned counsel for the appellant has submitted that as per the plaint, Schedule B property was a part of Schedule A property. He has submitted that the written statement was filed claiming adverse possession and
So we had purchased land in 1940.
on the basis of registered sale deed with respect to portion of 669 with respect to portion of plot number 669. The learned counsel submits that at the stage of trial, the parties contested the suit and two pleader commissioners' report were placed on record. One was by the pleader commissioner appointed by the order of the court, and other was the report which was privately obtained by the plaintiffs. He has submitted that the learned trial court rejected both the pleader commissioner's report by citing reasons and relied upon oral evidences to decree the suit. Correct?
As well as documents.
As well as
Documents available.
as well as oral evidences as well as documents on record. The learned counsel submits that so far as the appellate court is concerned, the appellate court has erroneously recorded a finding that the trial court had rejected the pleader commissioner's report appointed by the court and has relied upon the commissioner's report which was privately procured by the plaintiff. He has submitted that the appellate court has not at all discussed the oral evidences placed on record to come to a finding. The learned counsel submits that the trial court having recorded finding taking into consideration both the oral and documentary evidences placed on record, the appellate court could not have completely ignored the oral evidences placed on record and was also not justified in committing error of record while recording the findings of the learned trial court and observing that the trial court has relied upon the report of the pleader commissioner which was produced by the plaintiff privately. The learned counsel has also submitted that while doing so, the appellate court has not met with the reasons which was given by the learned trial court to give its finding. The learned counsel has relied upon a judgment passed by this court in essay number 28 of 2017, decided on 2/1/2025, and has submitted that in the state judgment, this court has considered the various provisions of law as well as the judgments, particularly in the circumstances when the judgment is that of reversal by the appellate court. The requirements to meet with the provisions of Order 41, Rule 31 of the CPC has been duly considered. He submits that the appellate court has reversed the judgment without meeting the reasons of the trial court and without considering and completely ignoring the oral evidences. The learned counsel appearing, and he submits that under such circumstances, the matter be remanded to the learned appellate court for fresh consideration. The learned counsel appearing on behalf of the respondents, on the other hand, has not been able to point out the discussion of oral evidences by the appellate court. He has also submitted that the appellate court has recorded a finding that Schedule B property was not a part of Schedule A property. The learned counsel has further submitted that no issue with that effect was framed, although
by the trial court.
by the trial court itself, although the materials were placed on record for consideration of the same. The learned counsel has submitted that in case this court is inclined to remit the matter to the learned appellate court for fresh consideration, it may be observed that the parties may point out the issues for point for determination before the learned appellate court afresh, so that the points for determination be considered on the basis of materials already placed on record. After hearing the learned counsel appearing on behalf of the parties and upon going through the impugned judgment passed by the appellate court, this court finds that the trial court, while considering the pleader commissioner's report, in
17 है क्या?
In paragraph number
17 होगा वो।
17.
Right.
10 है ना? 10 दिखा लो।
10.
10.
Page 18.
In paragraph number 10,
Both
Has
commissioners
considered
have
the-
committed mistake.
a report submitted by both the commissioners, which were Exhibit 5 and Exhibit D. And
Fit to be rejected. Fit to be rejected.
has recorded. Where is that recording?
It is both the commissioners have committed mistake by not committing measuring plot number 669
कहाँ पर है?
as
कहाँ
above.
पर है?
वो para 18 में पड़ा.
Last
para
18 के बीच में है, मिडिल में।
बीच में.
para 18,
नहीं para 10 का पेज 18 पर.
page 18. Yes.
para 19 में लिखा है. para 19 में कि in this I have fit to relate I have produced both the reports.
Yes.
In minuted distance, both committed vital mistake, not measuring
Yes.
the whole.
By recording that, after perusal of the report, both the reports, he has recorded that both committed vital mistake in not measuring the whole plot number 669. To show that the suit land was part and parcel of the land purchased by the plaintiff, and they were in possession prior to the alleged dispossession. The learned trial court thereafter considered the oral evidences on record and decreed the suit on contest and directed the defendants to hand over vacant possession to the plaintiff. This
Finding
court-
it at page 64.
Sorry?
We are finding it at page 64.
Yes.
Page internal page 21. I wrote that the plaintiff are purchasers of it and they are
Okay.
not.
The learned trial court also held that the plaintiffs were purchasers of the property and got title to the suit land, and they were illegally dispossessed in the year 1975. So far as the learned appellate court is concerned, the appellate court recorded that the learned court below has wrongly relied upon the report of the survey knowing commissioner Nageshwar Prasad Sinha, who was not appointed by the court, and illegally discarded the report of the survey knowing commissioner Narayan Roy, who was appointed by the court. Apparently, the said observation made by the learned appellate court is not tallying with the findings recorded by the learned trial court. This is over and above the fact that the learned appellate court has not at all discussed the oral evidences which were placed on record at the stage of trial and were considered by the learned trial court to arrive at a finding. Consequently, the appellate court, although the appellate court has recorded that the plaintiff failed to prove the title over the suit land and illegally dispossessed by the defendants on 12/6/1975 by oral and documentary evidence. This finding has been recorded without discussing the oral evidences placed on it. The appellate court ultimately reversed the decree. This court finds that the appellate court has not considered the reasons for grant of decree by the learned trial court while reversing the decree. In such circumstances, this court is of the view that the appellate court has not followed the mandate of Order 41, Rule 31 of CPC while reversing the decree. And the matter is required to be remitted to the appellate court for fresh consideration. The learned counsel for the appellant has rightly relied upon the judgment passed by this court in essay number 28 of 2017 dated 2/1/2025, wherein the various provisions of wherein the provision of Order 41, Rule 31 CPC has been considered, and also in that case also the matter has been remitted back for fresh consideration. Consequently, the substantial question of law which has been formulated by this court is answered in favor of the appellants and against the respondents, and the impugned judgment and decree passed by the first appellate court is hereby set aside, and the matter is remitted back to कौन सा कोर्ट है? To district judge, to the district and additional sessions judge Roman 5 GD for fresh consideration of the appeal in accordance with law. बाकी सब इश्यूज में तो कोई डिस्प्यूट नहीं, बाकी सब इश्यूज और तो कोई इशू नहीं रिवर्स किए हैं. In view of the submission made by the learned counsel for the respondent, it is sufficient to observe that if there is any point of determination which has to be recasted and based on materials on record, it will certainly be open to the appellate court to do the needful with the assistance of the parties. The parties to appear before the appellate court, fresh वकालतनामा फाइल कर देंगे आप लोग. By filing fresh वकालतनामा on, I will just give a date, at 11 a.m. the first appellate court shall make all endeavor to dispose of the title appeal expeditiously on the basis of materials which are already available on record, parties to cooperate. ये ऐसे 28 का 2017 का जजमेंट इसमें डाउनलोड कर लेंगे.
Notified case for orders notified at number 2nd April 17 of 2020.
Yes.
Lordship, IA number 730 of 2025 has been filed for condonation of delay of 21 days, Your Lordship. And IA number 731 of 2025 has been filed for a direction that the copy of decree of first appellate court may be sent below for correction and party position.
Where is my order?
Your Lordship, the order was passed by the coordinate bench, Your Lordship, on 11th of December 2024.
Remove the difference. And which is the IA number?
Yes, Your Lordship. IA number 731 of 2025.
You are seeking correction in party position.
Your Lordship, in the decree of
That's
first-
right, there is an error that has to be done.
Yes,
Or
Your
आगे?
And Your Lordship, one IA is 730 of 2025 for condonation of delay of 21
That's it,
days.
that you have already complied.
Yes, Your Lordship. So only for IA number 731. Your
Essay number 78 of 2020. The learned counsel for the appellant has submitted that an order dated 11/12/2024 has been filed directing the appellants to remove the defects pointed out by the stamp reporter within 6 weeks, failing which the appeal shall stand dismissed without reference to bench. However, an IA number 731 of 2025 has been filed to send a copy of the decree of the first appellate court for correction in party position. ये defect point out हुआ है?
Yes, Your Lordship.
She submits that such petition has been filed
After further stamp reporting, Your Lordship,
in
this
view of the defect pointed out by the office. But that is defect number 2. कौन सा defect number?
Yes,
Defect number 6, party position.
yes, Your Lordship.
With respect to defect number 6, she submits that defect number 6, it is not possible for the appellant to suo motu correct defect number 6. She has further submitted that a petition for condonation of delay has already been filed, and so far as other defects are concerned, there is no impediment in removal of defects. Considering the aforesaid submissions, the office is directed to send back the copy of the decree of the learned first appellate court for correction in the party position before the concerned court. This is कहाँ का matter है?
Your Lordship, Ranchi.
Upon deposit of special messenger cost by the appellant, ज़्यादा नहीं लगता 100
Yes,
रुपए
yes,
ऐसा कुछ
yes, Your Lordship will be at the.
by the appellant within a period of 1 week. In view of the aforesaid facts and circumstances, in view of the order passed by this court today, certainly the appeal cannot be dismissed on account of non-removal of defect number 6. That's it?
Yes, Your Lordship.
इसमें कोई डेट होगा ना? पोस्ट ऑन एक कोई डेट दे देते हैं 25 फरवरी
Your Lordship.
या उसके बाद 11th मार्च पोस्ट ऑन 11th मार्च.
Date, Your Lordship.
From supplementary list of final disclosure, item 2, first appeal 25 of 2024.
Yes, appellant.
behalf of Mr. Jharkhand, I pray for time LCR इंस्पेक्ट नहीं कर पाए.
ऐसे टाइम नहीं होता. सुबह से यहाँ बैठे हुए हैं 3 घंटा में LCR क्यों नहीं इंस्पेक्ट किया? क्या मैटर है? रेस्पोंडेंट अपीयर हुए?
No, they denied.
Refused to accept.
Yes.
My lord, respondent शेयर नहीं हुए हैं, but इसमें इंटरवेनर एप्लीकेशन मेरा रेडी है, उनको फाइल करना
आप कौन हैं
है. हम रियल लैंड ओनर हैं और ये मुगल सराय के दोनों लोग रहने वाले हैं. प्लेंटी फॉर डिफेंडेंट.
तो आप इसमें
इंटरवेनर हम ट्रायल कोर्ट में फाइल किए थे. That was rejected. Thereafter, we have preferred CMP before this honorable court. In between pendency of CMP, the case was decided. Then I have withdrawn the CMP. And this intervener application is. He is the real owner, and they are fighting for my land. And defendant is deliberately not appearing, right? Because they are living in same locality in the Mughal Sarai, and he is deliberately not appearing before this honorable court also, and before the learned trial court itself also.
तो आपको इंटरवीन क्यों करना है?
Intervene थोड़ा सा हम
नहीं
फाइल
क्यों करना है? The
हमको करना
decree
है
will not be binding on
Yes,
you.
yes, but my lord, this is my property, and
तो
he is
कौन
not appearing, he
execute
is
कर
not
देगा
protecting his case, my
You
lord.
see, whenever any execution is filed, you will have your right.
Yes,
Because they have not made you party deliberately.
deliberately.
So be happy with that. The decree is not binding on you.
No, my lord, but after if he will case will decide in favor of him, then court direct to register the sale deed in favor of him.
It is specific performance of contract.
Specific for contract, yes, my lord. So I am a necessary party. So in my land, for my land, they are fighting each other. Showing the amount of 10 crore rupees, final amount, and 9 lakh rupees has been given advance without any date, without any application for showing the ready to perform his part of contract. On this ground alone, the judgment was decided against the plaintiff. Yesterday, my client has come. I have prepared the application. Could not find it is ready. I will so establish before my note that I am a real owner with documentary evidence.
What is the just don't know. They are seeking time and you are also seeking time.
Yes, my lord. Since I am not a party, so I could not pray, but in the interest of justice for my client, I am submitting. It may be only for not today, so that I can file my interpretation application.
You filed CMP
Yes, my lord, before this honorable court. That was dismissed as withdrawn.
under 227.
Yes. Yes. I have may kindly see my report.
Why did you withdraw it?
As because the matter was infructuous.
Have you said so?
Yes, my lord, in the order itself. It has come in the order that this is my intervenor for kind of last page, my lord, order before Wakalat.
The learned counsel for the appellant seeks adjournment. आपके बारे में हम कुछ नहीं लिखेंगे because you are not there in the
Yes.
picture so
Yes.
far.
Yes.
कब रख दे बताइए? आपका सूट डिसमिस हो गया?
Yes.
Yes.
तो आपको तो कोई मतलब नहीं, टाइम ले रहे। कितना? 1 साल, 2 साल, 3 साल, कितना?
CR expect नहीं
कितना टाइम लेंगे बताइए?
to
The learned counsel for the appellant has submitted that the records have been received and he wants to inspect the records and submits that the matter be posted after 2 weeks. Post on 5th of February in the supplementary court.
Much
No adjournment will be granted at the instance of the appellant.
much obliged.
Nobody has entered appearance on behalf of the respondent.
From supplementaries for orders with effect. Item 3. First appeal filing number 10976 of 2024.
was in this count. The IP council will connect with the rest of this.
This is first appeal.
This is first opinion. There's a issue of maintainability raised by the
There are other defects also.
Plus, there's only one surviving defect regarding the type copies minutes for which the IA has been filed.
What IA?
The IA number is 12988 of 2024.
Saying what?
Plus, for ignoring the type copies minutes.
Why? Why it should be ignored?
It's illegible.
We are not supposed to read those documents.
Because they are receipts, post-received pictures of the identity card. They're not
See, in a
relevant for
case
the
of-
adjudication. They're not relevant for the adjudication of the instant agreement.
the dispatch of the speed post, the date of the speed post, these are not relevant. The original must have been exhibited before the court.
That's not. Original has not been exhibited because the case was dismissed for default. Because the arguing counsel has
Case was
joined
dismissed
Lord's.
for default.
Yes, ma'am. Because the
Yes.
arguing counsel has joined Lord's.
Where is the decree? Decree was prepared or no decree was prepared? Where is the judgment?
The speed number 21 starts. Annexure 1.
Annexure A1 also.
Page number, please.
I was page 21.
You have not filed certified copy also.
This is certified copy, no?
No, we don't have that certified copy. I don't know, you must have filed it later.
Yes, ma'am. After that.
Where is the certified copy? There is another certified copy dated 22/8/2024.
Yes, ma'am. That is the order that we have challenged. Well, there are two orders that we challenged. Then we were asking Lords that we can only challenge one impugn order. Thereafter, Lords, we've challenged the subsequent order, which is 22/8/2024. We filed a restoration application, Lords, to restore our suit, which was also dismissed, against which we have appealed.
So this appeal is against what?
Lords,
Dismissal
arising
for
from-
default or the against the order refusing to restore?
Lords, both.
My lords, may I submit?
Yes.
My lords, I am appealing from Delhi. The earlier council filed the restoration, which was dismissed, and thereafter we filed an application, and both those orders have merged in terms of
No,
Kunayam and Advent,
no. They do not merge.
because there is an adjudication on the same issue.
Yes. No, it is not the adjudication of the same issue. They do not merge. The contours of adjudication of restoration application is different.
My lords, this is an issue of dismissal in default under Order 9. A restoration was filed thereafter, and that restoration was adjudicated. Thereafter, we are here before this honorable court, praying for a restoration. And the earlier
Yeah.
council who was
In this first appeal, which order is under challenge?
My lord, the order
We
dated.
will see your prayer. Which order is under challenge in first appeal?
These lords. Order dated 22nd August 2024. This is at page 23 of the paper book.
Okay, so you challenge the order refusing to restore.
Yes, my lord.
The earlier order dated 1/7/23 is not under challenge. That has been deleted.
That is merged into order dated.
That has been deleted. So
That's my full submission.
okay. So you have challenged the order dated 22/8/24.
But yes, my lord, there is another issue. Our local council could not inform it. The nomenclature of the appeal has been listed FA. This has to be a commercial appeal before the commercial appellate court. So if my lords may give us permission to make the necessary amendments and have it listed before the concerned court.
Has the commercial court passed the order?
Yes, my lords. This is an order by the commercial court.
You find your interlocutory application. We can't do anything about it. How is it
Yes.
listed at ये first appeal कैसे mark हुआ?
It's the defect on maintainability has been pointed out.
No, but still, this has to go to the division bench.
Yes, ma'am.
Yes.
It has to go.
You have deleted the provision of section 13 of the Commercial Codes Act. Why
My
have you
lord, yes.
deleted?
This was not done under our instructions. This was done to get matter listed. Unfortunately, the appeal is a commercial court appeal. This was supposed to be filed as a commercial court appeal. The nomenclature got incorrect.
learned counsel for the appellant. नाम बताइए अपना. Your name.
Samuel Gonzalez, my lords.
Give it in writing.
Please.
Has appeared online along with Mr. Your name.
Salish Pudar.
Salish Poddar, who is present in the court. The learned counsel for the appellant has submitted that the order impugned in this case has been passed by the learned presiding officer, Commercial Court, Ranchi, and the commercial appeal would lie against the same. You have filed the plaint?
The copy of the plaint has been filed.
Where is it?
Well, the plate starts at page 28 of the web book.
28. The value was 44 lakhs.
Yes, my lords.
Please find it out. I'm not
Within-
sure. No,
within-
value was 44 lakhs.
Yes.
Please find it out from the procedure of Jharkhand. I think the appeal may lie, I do not know, you have to verify it. May lie before the commercial court in the district, not in the commercial court over here.
I
Because-
will check on it.
Because there are two-tier system of the commercial court in Jharkhand.
I'll examine this one.
The suit was valued at rupees 44 lakhs 28,340. The learned counsel submits that. The learned counsel seeks adjournment to file seeks adjournment and submits that appropriate petition is required to be filed to amend the memo of appeal as the provision of section 13 of the Commercial Courts Act 2015 has been deleted from the cause title pursuant to certain office objections. आप जरा पता कर लीजिएगा 96 में ही यहाँ फाइल हो रहा है. We do not know. The learned counsel has also submitted that we shall also examine as to whether the appeal would lie, appeal if any, would be maintainable before this court or it would lie would at all be maintainable before this court. That should be sufficient. How much time do you need?
My lords will give us 3 weeks for us to dispatch the affidavit from Delhi.
The learned counsel prays for 3 weeks' time.
Obliged.
Post on put off after 3 weeks. I do not know what kind of petition you are going to file. I am not fixing a date because you have to file, the office will take care of it.
Grateful, my lords.
Take the next.
Item 4, first appeal filing number 11042 of 2024.
Mr. Poddar, you take care of this. Find it out, the hierarchy over here.
Yes, ma'am.
Yes,